Good morning. Good morning, everyone. I'm just going to wait for some of you guys to tune in. Say hi when you come in. Let me know where you're tuning in from. If this is your first time joining, definitely let me know in the comments so I can give you a shout out. I'm just going to, good morning, Facebook. Good morning, YouTube. Good morning, Instagram. Okay, so let me introduce myself. My name is Aisha Chidole. I'm an immigration attorney, and I present clients all over the United States with their family immigration matter. Either you're outside the country or within the country, as long as you'd like to immigrate to the United States, I can assist you. My phone number here is 407-995-6567. You can also send me a WhatsApp, 404-333-8751. Good morning, O'Hara from Brooklyn. Good morning from Jamaica, New York City in the house. Good morning. Good morning. So today I want to talk about frequently asked questions about petitioning for a VAWA green card, and questions that I get asked all the time, and just sort of break down some common questions and answers one time. So this is a good video to save. Also, a good video to share with your friends, your family, uncles, aunties, grandmas, cousins that might have an immigration matter. Good morning, Justina on YouTube from LA. Super early for you guys right now. So let's first of all start with what exactly is VAWA before I talk about the frequently asked questions. So, I know I've told you guys several times, VAWA basically means Violence Against Women's Act. And even though it says Violence Against Women's Act, it also applies to men. It also applies to women. It also applies to children. It also applies to people who are in same-sex marriages. And it also applies to parents. So essentially, the idea of this rule is that, if you're in an abusive relationship by somebody who has a certain status, which I'll get into in a second, you might be eligible to get a 10-year green card on your own as a self-petitioner. Okay, so who are the people that would qualify for that? So number one, if you are married to a U.S. citizen or a green card holder and your spouse is extremely cruel to you or abusive, you could qualify for this to get your 10-year green card on your own. And what confuses a lot of people is the word self-petition. So again, remember, when you do a marriage-based case, you usually need somebody to sponsor you, or to do your financial affidavit of support, or to be a petitioner. With VAWA cases, you do not need anybody to sponsor you. You do not need your spouse or your abuser involved in any way. Okay, so that's with the marital side. For children, it is either your parent, step-parent, who's a U.S. citizen or a green card holder, that can make you eligible if they're extremely cruel to you. And then for parents, your it is only your U.S. citizen child who's over the age of 21. So if your child is under the age of 21, they cannot, you're not eligible. And I see here that it spelled my FAQs wrong. This is what happens when you voice note your title. So ignore that. That's meant to say FAQs. Anyway, so some of the questions that we typically get, of course, majority of the time you find it with abusive spouses. So we get a lot of questions about, good moral character, what is required, what if I don't have this evidence, blah, blah, blah. So I just want to break down as many of them as I can. If you have any in particular that you want to ask me about, you can ask about it. So the first question that we get, the most common question is, I don't have a police report. How can I show that my spouse was abusive? So a police report is not required to show that your spouse is abusive. USCIS understands that a lot of people truly have fear in reporting their spouses, because a lot of spouses threaten you that once you contact the police, you're going to be deported, or I'm going to lie, and I'm going to, and you're going to be the one that ends up arrested or deported. So if you have a police report, it's helpful. Absolutely, it's helpful. But a police report does not determine whether you're going to be successful or not. We have many clients who are successful without a police report. Okay. The other thing that people always say is a psychological evaluation necessary, right? Here's my stance on psychological evaluation. When you can and if you can, it's always good to have, especially when you cannot document physical violence. So, as you guys, if you've watched me, if you know that physical violence is not the only way that people can be abusive, and sometimes the emotional and psychological abuse are actually much worse than the physical stuff. And while you can say, I'm depressed, I've not eaten, I've lost weight, I have heart palpitations and all those things, there's so much more weight when that comes with, a psychologist, or somebody who is able to make that determination in a psychological evaluation and say, Jane Doe definitely is experiencing depression or anxiety or post-traumatic stress, from this situation. So that is usually helpful if you can get it, especially if you don't have other documentation, like much, evidence. That's certainly helpful. Another thing that's helpful is if you go to, like if you see your doctor because, you're very stressed and you're dealing with that, story time. Let me tell you a quick story. I always give you guys like one story or the other. I remember we had a client who, somebody else represented her, and basically she got an NOID. An NOID basically means a notice of intent to deny, for her VAWA case, because, they felt like she didn't have any evidence or nothing, basically whatever she submitted was not good enough. So of course, we presented a declaration, which is basically her personal testimony of what happened. But what really helped, even though she didn't have any police report, she didn't have any psychological evaluation, was simply going through the archives and finding her doctor's notes, like where we're able to log in to her doctor's, like her client, her whatever patient portal, and we're able to go through those notes and find on there where he specifically put on the notes that she's here because she's been dealing with anxiety and depression due to her husband, and listed her spouse's name. I don't know, Instagram, it's saying poor connection. I hope you guys can still hear me on Instagram. It says my connection is poor, but let me know if you can hear me on Instagram. But as I was saying, yes, and I see that I am frozen. All right, Facebook and YouTube, just hold on. Let me fix my Instagram and see what's going on. Can you guys still see me on Instagram? Oh, it's going in and out. All right. If you're on Instagram, I'm going to disconnect and reconnect right back. Just give me a second, guys. I don't know what's happening. Is it back? Can you guys see me now? Like this month, I am having the worst time with my Wi-Fi in this office. Let me know on Instagram if you guys can see me still. If not, I will disconnect and reconnect. But as I was saying, we were able to find in her doctor's notes where he specifically wrote that one of the reasons why she came to see the doctor with an elevated heart rate was because she was dealing with stress, from her husband, and, her husband's name. And that was enough for us to get a win because, even though she didn't have anything else, just being able to have that doctor show that, she was experiencing that level of anxiety, and, he referred her to a therapist. So she didn't go to the therapist, but just being able to see that in a doctor's note really helped her case. So, again, while certain things are not a requirement, where you can get it, if you can, but you not having it is not the end all be all. Another thing that's also helpful is if you are like a member of a if you're a member of a church or mosque, you're Jewish, basically if you go to your elders in your religious, whatever your religious persuasion is, they can also write a letter. Like, so, you can have your pastor, if your pastor has ever evaluated you, couples counseling. Like, these are all different things that you can use to show problems in your marriage, without necessarily having a psych evaluation. So if you have those would still help. And then another frequently asked question that we get as well, I don't have much, I don't have a lot of evidence, what am I going to do? Like, how can you win this case or whatever? So the rules for VAWA is this: any credible evidence, any credible evidence. And what does any credible evidence mean? It means any evidence whatsoever that you have that is legit. They will take all evidence into consideration. There's not one or two things that's going to make or break a case. It is a gathering of everything you have, and asking themselves the question, is it more likely than not that this person is dealing with abuse? If the answer is yes, most likely you're going to see an approval, And for some people, what that looks like is they might have a spouse who's so abusive and so controlling and truly understands the immigration system that they're not willing to even put them on anything with their names on it, like on any lease, on any utility, on any bank statements. So you have to be strategic in explaining that. Yes, of course, it's not an ideal situation, but being able to explain that, and why those things happened, in a way that is credible, are things that will potentially help your case. Okay, so let's see. Let me see if you guys have any questions for me. Some other frequently asked questions. Okay, I'll do 2 more frequently asked questions before I start taking questions. The other frequently asked questions is about the cohabitation requirement. Some people generally ask, well, we didn't live together for a long time, or we don't live together right now, how does that affect my case? So with VAWA and a marriage, cohabitation is a requirement that you should have cohabitated. Like I mentioned to you guys a couple weeks ago, the rules changed in February. So what that means is that cohabitation can happen prior to marriage, or after marriage. So if you guys were living together or you lived together at some point before marriage, that will count, even if you're no longer living together. Same thing if you were living together after marriage, that will count. There is no minimum time that you have to have been living together. So even if you've been living together for a month or 2 months, but as long as you can show that you lived together that time in a way that is credible, you can still win your VAWA case. And then the last question I'm going to talk about, and I get this all the time, is about divorce. People always want to know, should I divorce my spouse? Can I still stay with my spouse, or can I divorce my spouse? As I've always told you guys, divorce is a very personal matter. So myself or no other lawyer will be able to tell you whether or not you should divorce your spouse or not. But if the question is that, does it affect your petition if you get a divorce or if you stay together? The answer is absolutely not. Whether you choose to get divorced, whether you choose to stay together, whether the abuser is a petitioner basically means the one who filed, or whether you, the abused, is the one who filed, it is not what they use to determine your case. Now, if you do get divorced, you want to make sure that you've submitted your VAWA petition within 2 years of the divorce. If you submitted 2 years and 1 day later, you are 1 day too late. So you want to make sure that you submit it on time. And then the last thing I'll say about divorce is that if you do get divorced and your case is still pending, you cannot remarry while your case is still pending. If you remarry, basically you're saying goodbye to your VAWA petition. So that's that. Let me see if you guys have any other FAQs related to this, and I'll answer it. All right. Let's go through. Sorry guys, I know my fingers are like in my Facebook. I'm like trying to scroll through my cell phone. Good morning, ever blessed. Let's see who else is here. Good morning, Chris. Okay, I guess this is where I got disconnected. You guys can see me. That's good. Good morning, phenomenally ambitious. This Destin said, if someone already lied in his I-9 to get a job, can he still get his VAWA, or do I have to quit the job? Well, what did you lie about in your I-9? You can't claim to be a U.S. citizen, because if that's what you lied about, you're not going to be able to get your green card through a typical adjustment of status. Okay, I really don't know what's going on with my Instagram. I keep going in and out. If you guys want to, you can jump on to Facebook or YouTube, because I'm not really sure what's going on with Instagram. Um, then Christina on YouTube says, can relocating to another state affect your pending VAWA case? No, but it can be messy if you don't update USCIS that you've changed your address. Unlike a normal marriage-based case where you can update your address online, you cannot update your address online with a VAWA case. You have to update your address by mail. So it is really important that you update them. The reason why is because even though most VAWA decisions are going to be made in one state, which is Vermont, regardless of where you live, they have, in order for them to process your adjustment of status and to send it to the right field office, they need to know where you live so that they can determine where you have jurisdiction. The same goes for your biometrics. So if you do change your address, it's really important that you let them know. Okay. So what is fee waived in VAWA, and can I still file for work permit and advance bureau after a year of an I-360 pending? Fee waived in VAWA just simply means that your I-360, there is no fee when you're submitting on the basis of VAWA. When you're submitting on the basis of VAWA, this is only for your I-360 alone, your I-360 form. There is no fee if you're using that form for VAWA. There is a fee for adjustment of status, which is your green card application. That's your I-485, and for your biometrics. But you don't typically pay the VAWA fee, which is a 360 form. Okay. As far as whether you can apply for work permit and advance bureau, you can, but something has to attach to it in order for you to apply. So you have to submit an adjustment of status, which is an I-485, in order for you to do advance parole and work permit if you didn't submit it initially with your I-360. And that's fine, even if it's been, a year ago. So Stephen on Facebook says, good morning. If someone did biometrics 5 months ago, is it too early to get an answer from USCIS? Well, the answer will depend on what you did, what you filed, and what you did biometrics for. So you can let me know what you did your biometrics for, and then I will let you know. Okay. If you have a 10-year green card and just get your something about medication, wait, I don't understand. Are you saying the doctor gave you medication that got you injured in your liver? Is that what you're saying? Can I still have my citizenship? So your sickness status or your health status does not determine whether or not you can get citizenship. There's no medical exam required for citizenship. It's not the same as a green card. However, if you're asking this because maybe I don't know if it affects you from a memory level and you need some sort of exemption from the civics test, then you just have to have your doctor, complete a form basically saying that you're exempt from that. But you being sick does not affect you from getting citizenship. Okay. All right, let's see. How long does it take for VAWA to get working permit? So you're asking how long does it take if you have a VAWA case to get your work permit? The answer depends on whether you applied with an adjustment of status or not. If you apply with adjustment of status, honestly, it was taking about 5 to 9 months. Knock on wood, in the last 2 weeks, we've been seeing some work permits from 4 months ago come through. So hopefully what that means is that it's going back to pre-pandemic times where we used to see them more on average between 4 to 6 months, but generally we see them 5 to 9 months. Good morning, Nash. Uzama says, if you remarry the same person after divorce, will it affect you renewing your conditional green card of 10 years? When you say you remarry the same person, are you talking about the person who gave you the green card, or you're talking about a spouse before that? Because depending on the answer, yes, there's a potential red flag here. It doesn't automatically mean a denial, but there's a potential red flag, and you really have to have some solid evidence that you didn't enter the marriage that gave you a green card due to immigration fraud. Okay. Okay. If I'm filing VAWA with my underage kids on it, how long will it take the I-130 to be approved for them to come to the U.S.? So this is how it works, okay? First of all, it's not an I-130 that you file when you have a VAWA petition. You file an I-360. When you submit an I-360, you don't get to decide whether you're adding your children or not. Once your children are under 21 and they were not born in the United States and that they're not green card holders, USCIS will automatically include them in your VAWA petition only. So they're not being included in your adjustment of status application. They're included in your VAWA petition only. If your VAWA petition gets approved, again, this is your VAWA petition only. If your VAWA petition gets approved, so do the VAWA petition of your children. When that gets approved, they go through a very different process than you who's here that continues to an interview based on your adjustment of status. Your children first have to have, there's a process called an A21 where they then have to request a transfer of their approved file to the National Visa Center. Like, this is a brand new application. So if you're working with a lawyer, you'll be doing this. This is different. This is a new process they'll be doing. And when it gets to NVC, complete the visa application. But the basis of them getting the green card will be based on an approved I-360. So I hope this is clear. I know it's a little bit confusing, but it is not the same as you here doing an adjustment of status if your children are not in the country. If your children are in the country, meaning in the United States, when you're submitting your VAWA petition, you can also submit individual I-485 petitions for each child under 21. So that way, if you get approved, you will all be getting approved at the same time. This only applies if the children are in the United States. If they're not in the United States, the process is different. So hope that's clear. Okay, let's see if I can get one or two more questions. Destine said, that is what I claim. Just barely got the job because I need the money to pay for my case. Destine, I'm really, really, really sorry to break it to you, but you will not qualify for a green card. If you wrote that you're a U.S. citizen, you guys, I've said this several times, that is the one thing that USCIS is not forgiving. If you wrote on any documentation that you're a green card and they pull that stuff up, and usually how they're able to tell sometimes is there's certain companies or certain companies that, because of the size of the company, they should have E-Verify and I-9s, and they will verify that. So if you wrote you're a U.S. citizen, they don't really care that you were doing it because you needed to survive. You're not going to get your green card. Now, if you were working under the table and you never submitted any I-9 or claimed to be a U.S. citizen, and you're married to a U.S. citizen, USCIS will forgive that. But once you put on paper or tell your employer that you're a U.S. citizen to get that job, they're not going to forgive that. Okay. Everbless said, do you have to do biometrics before getting a work permit? Yes, you have to do biometrics for every single thing that you file to USCIS. Whether or not it's a work permit, whether you filed a petition 2 months ago and you're filing a different one 2 months later, everything that you submit, you must pay for the biometrics fee. Now, when you pay for the biometrics fee, USCIS can decide that, you know what, the biometrics we have on you is still fresh, so we're going to bypass it, but we're not refunding you the money. So you must pay for the biometrics fee, but USCIS will send you a letter and say, we're either going to do a bypass of the biometrics, or we'll send you the biometrics, I will tell you, though, that a lot of the bypasses that came during COVID, later on, they started calling them back for biometrics. So there's still a possibility that if you get a biometric bypass, that they will still call you back for biometrics. Okay, let's see what else we have here. Okay, so Casey says, I have an I-130. My I-130 says, actively reviewing since this year, February. How long before approval? I can't tell you. I don't know how long before approval. I don't know what stage you are in your case. I don't know if you only have an I-130 standalone. I don't know. So it's hard to say without more information. Joe Houston said, good morning, the law. You're a blessing to us all. You're welcome. Thank you. Um, Clara Kiana says, with VAWA alone, I did my biometrics last year, and it's been 13 months since my I-360 was submitted. What's next? Okay, so that's normal. Most VAWA cases take 2 years to 2.5 years. So you're still very much within the timeline. And what's next after the biometrics, when you have a VAWA stand alone, is you're going to get, when your case is approved, a work permit. So this work permit is different from the one that you submit when you submit an I-765 based on a 485. When you get this work permit as part of your VAWA standalone, then you know that for a fact you've been approved for your VAWA case. But for some reason, the work permit usually just comes a few months before the actual. You will see on the date that the approval was the date that they issued you the work permit. I really don't know why they do it that way, but that's kind of how it works. Okay, so this is the last question that I'm going to take. T Mile says, what does prima facie mean in VAWA? A prima facie basically means that you've essentially met the preliminary requirements to be considered a VAWA victim. And preliminary requirements are things like good moral character, meaning that you don't have any crimes of moral turpitude, good faith marriage, extreme cruelty, and cohabitation requirement. And a spouse is a U.S. citizen or a legal permanent resident or your parent or your child. If you meet all those 5 things, was it 5 or 6? I don't know how many things I mentioned. If you meet all those 5 things, you're going to get a prima facie determination letter. And the prima facie determination letter, the benefits are different depending on what state you're in. In some states, it will allow you to get it will allow you to get a driver's license while you're waiting for your work permit and travel permit. And otherwise, in some states, it will allow you to get public assistance if you need it. Some of them have prerequisites in order for them to give you the public assistance. And then finally, it will allow you to get financial aid for school if you want to go back to school. Usually all your children that are under 21 that are U.S. citizens will be listed as your derivative beneficiaries in your prima facie. And how it works is you will get a 1-year prima facie, and then once the 1 year expires, automatically they'll be giving you 6-month increments of the prima facie determination letter. Please, I want to note that a prima facie determination letter is not a guarantee of approval. Yes, it means that your case is moving in the right direction, but it is not a guarantee of approval. They're just giving you the basics so that you can use a fine-tooth comb to now review everything else. I got to jump off, guys. I have a meeting, but I hope you guys have a wonderful day. Subscribe to my channel, save my link, save my Instagram, hit the notification button on Facebook, on Instagram, on YouTube, share this video. So you know when I tune in live. And then call our office if you need help, 407-995-6567. Talk to you guys later. Bye.